So moving on to malicious prosecution, what makes a case like it's just a favorable disposition, or what about the actual prosecution of the case makes it malicious as compared to not?
Yes, people are gonna kill me about maliciousness because malice is an element of malicious prosecution. Malice can be inferred upon with lack of probable cause. Okay, so if you arrest someone without probable cause, you can infer that that's malice. That's good enough for pleading. For trial, it may make a little bit of a difference. But basically saying that it's all the elements of false arrest except you had a favorable termination, meaning the case was dismissed. So, for a false arrest claim, like you said, it doesn't matter whether you were guilty or not. For a malicious prosecution claim, it doesn't matter whether you were guilty. It doesn't matter whether you committed the crime. If you committed the crime, even if your case is dismissed and you committed the crime, you're tough. It's a tough sell.
So shit, like a lot of cases get dismissed, especially due to the new discovery laws. If your case gets dismissed, does it automatically have a value as a malicious prosecution case?
It could, but
depending on what.
Well, you have a favorable termination, so it's dismissed. The question is like, well, did you do it or not? Because if they dismiss, like you said, for discovery, they still have probable cause. It doesn't matter. You don't have a claim, right? You can't. Like I said, if someone comes to me like I was arrested, my case was dismissed, I'll take a look at it. But the reality is that if they had probable cause at arrest or they got probable cause later, it's nothing about malicious prosecution, is that they can get at any point in the prosecution they can get probable cause.
So you have a girlfriend makes false accusation and you assaulted them. It's bullshit. They don't want to cooperate with the prosecution. They don't pick up the phone. Case gets dismissed. That might not be considered malicious prosecution.
Well, it could. No, wait, no. Let me correct myself. It's not because you got probable cause. And also, a lot of malicious prosecution, malicious prosecution only really has value if your case went on for years or you spent a lot of time in jail. So that in that instance, that person who gets ROR because of misdemeanor in New York, they get released on reconnaissance. That means the only claim for damages is really going to be the false arrest claim because they only went to court 2-3 times. You got to go to court at least probably like 3 times to get a malicious prosecution claim if you're out. And then if you're and even then you gotta show damages. You gotta like lose your job or something like that. If you're just unemployed, you gotta go to court. I mean, there's no money in that.
Well, I remember I had a case which rarely do I tell my clients like you should sue. You should sue. This is crazy. But I had a case. It was a dumbass case. It was a aggravated harassment case, right? In which they're in a parking lot, right?
Aggravated harassment.
And this old dude is accused of telling the complainant to drop dead. So I argue at arraignments. I'm like CPL 145.45, which is 140.45, which is basically on its face they have not made out the charges because telling someone to drop dead is not a threat. It's not a threat that.
A threat has immediacy. No, immediacy of you carrying it out.
Exactly.
So I'm going to kill you.
I'm going to kill you. And you have to be reasonable to think.
I'm going to kill you tomorrow.
That's not threat.
Tomorrow would not be immediate.
That would not be immediate.
Or I'll kill you if it becomes an if statement, then it's not immediate. Because it's saying like, if you fuck my sister, I'm going to kill you.
Right.
You got to fuck my sister first.
Once you fuck the sister, then I'll be on alert. You know what I'm saying?
And then you end up dead.
I didn't think she gave it up like that. That's fine, bro. You better watch out. Right. If it becomes a promise.
Right. So it was like they got into an argument and he told him drop dead, like kill yourself, basically. So I argued that at arraignments, like this is on its face. In theory, which just you never get a judge to agree. If you make the argument of CPL 140.45.
That's pretty bad, though. Drop dead is aggravated arrest. That's pretty bad.
So if you make that argument at arraignments, in theory, the case should be dismissed right there because the argument you're making to the judge is that you don't have jurisdiction over my client because it's almost like they charge you with assault, but the words of the complaint don't say you assaulted them. Right. It says you curse at them, so it's not assault. Then that you don't have jurisdiction for that claim because they haven't made it out on its face. Right. That's a very low bar. It's like you just accuse them of what you're accusing them of.
Right.
The judge agrees, but is not willing to dismiss it, and says, "Hey, you guys gotta rewrite this. Rewrite this. Have it rewritten on the next court date." The next court date, these motherfuckers change it to disorderly conduct because they say that he was causing, like, that he was rambunctious and he's causing a scene in these statements. But I'm reading the complaint, but I go, man, this is in a parking lot. There are no other people. Disorderly conduct requires, like, you have to
Scene.
you have to call.
Try to cause a scene.
Yes, like you
Right.
you can't have disorderly conduct in a vacuum. If it's just me and you in an apartment building, it's not disorderly conduct because you have to.
Even if we're arguing, you gotta like try to draw a crowd in.
Right.
Exactly. So it's like, how are you changing this? Now you get into the level of malicious prosecution because you guys are so thirsty to keep this case
Right.
that you guys are making up charges that don't. That
Oh,
you double down on